Good evening. This is Making the Case. I'm Yodit Tewolde. Today, for the first time, a jury heard testimony from one of the former Minneapolis police officers charged in connection with the murder of George Floyd. Thomas Lane, Jay King, and Tou Thao all face federal civil rights charges for failing to provide medical aid to Floyd as Derek Chauvin kneeled on his neck. On the stand for a full day today, Tou Thao, the first of the three defendants called to the stand, tried to make the case that his role during that May of 2020 incident wasn't to restrain Floyd, that he played a different role, one that was focused on keeping the growing crowd at bay and not on Floyd's well-being. Here to talk through other notable moments from Thao's testimony today, criminal defense attorneys Sue Ann Robinson and Tony Thedford. Glad to have you both on tonight. Listen, let's start with the beginning of Thao's testimony, which, according to reporters in the courtroom, was the only time that the former officer got emotional. He talked about why he became an officer, which stemmed from a childhood experience of having Minneapolis police called to his home for a domestic violence incident involving an abusive father who beat him and his siblings. Now, for more than a week, prosecutors depicted Thao and his co-defendants as these cruel and heartless cops who didn't care for the well-being of someone in their care and custody. Now, here is the defense's opportunity to sort of peel back the layers a bit and give the jury a glimpse of this defendant beyond that one day in May of 2020. Sue Ann, knowing this about Thao could benefit him with the jury, yes?
It could, but at the end of the day, the prosecution has to make the case that, listen, we're not saying that these are bad individuals as persons. We're saying that what they did on that day is fail to intervene when Derek Chauvin was kneeling on George Floyd's neck, which led to his death. And that's the bottom line. They could have gone to church. They could give out cookies on the weekends. They could play basketball with underprivileged kids. They could do all that. But on that particular day, they made a bad call. And that's the bottom line.
Well, tugging at the heartstrings of jurors is pretty standard operating procedure for both sides. But what I think was incredibly effective was when the defense showed several pictures of Thao during his time in the training academy, which included one that showed a cadet pinning someone who was handcuffed to the ground in prone position with knees to the back and neck. It supported Thao's claim that he was always taught to use his knees to keep a suspect pinned to the ground, that this was something that was typically taught in the academy and that no one had ever told him that it was improper. Tony, this gives something for the jury to think about, right?
I think so. I believe this particular officer, Thao, is probably in the better position from the other two officers who are his co-defendants. First of all, because he never touched George Floyd. Second of all, he can rely on sort of this technical, this was my role at the time, as clearly indicated by the fact that I was here and they were there. Particularly his role of crowd control and those sort of things. This whole piece about the training regimen is at issue there in Minneapolis and is subject to another lawsuit that has nothing to do with this case. So I think the defense counsels are relying on what is this pending issue regarding their failure to properly train with the Minneapolis Police Department. They're currently trying to right their ship, as we know, based on the testimony at the Chauvin trial. But they still have sins that they have to pay for and account for. And I think Thao is trying to use that to try to slip out of this thing. And it may be effective.
Well, when it came to the actual encounter with George Floyd, Thao tried to make clear that he had nothing to do with Floyd, as you stated, Tony, physically, that he had no idea about the seriousness of Floyd's condition until after paramedics took him away. I've got my thoughts on how reasonable that explanation really is, but I want to get your take on that, Sue Ann. Was it reasonable for him to say, well, I mean, listen, my job was to keep the crowd away, to keep cars from running over, my colleagues and George Floyd. I had nothing to do with whether he was being taken care of or not. I thought that was already handled.
Yeah, I think I don't think it's reasonable, and here's why. If you are on crowd control, the picture you get in your head is a large crowd. people going back and forth. There's big issues. There's the crowd that he's talking about, as was discussed in Derek Chauvin's trial, includes a juvenile that's wearing a love sweatshirt. This is who he is controlling, and his attention is so drawn away from the condition of George Floyd that he can't do anything else but focus on this crowd. This crowd, which includes two younger women and a child that's wearing a love sweatshirt. Here, also, the crowd that he's controlling is saying that George Floyd is in distress. George Floyd is dying. George Floyd is having these issues. He's not breathing. He's keeping his knee on his neck. The crowd that he is so laser focused on is actually saying and giving warnings as to George Floyd's condition. So is his argument that he's so laser focused on the crowd that he's not actually paying attention to what they're saying, and that him not paying attention to what they're saying means that he's not taking note and saying, okay, wait, they're saying there's some issue. Let me look back and see what's going on, or let me look and see what's going on. It just makes no sense. You can't say that you're focused on the crowd, so laser focused that you can't do anything else, when the crowd is alerting you to the condition of George Floyd the entire time. That's literally why they're there, because they are concerned for George Floyd's well-being.
Tony, you mentioned that you thought that Tou probably had the better chance, I guess you're saying, of his co-defendants for maybe being acquitted on some of these charges, like maybe failing to intervene or failing to provide medical aid because he was at a distance and was never physically involved with George Floyd. But I think that Lane is probably the co-defendant that has the better chance because, one, even though Tou is claiming that he's been taught that the knee can be pressed against a suspect's neck or back, even in prone position, that may be true, but don't you think that that sort of flies in the face of, well, if they're not actually resisting, should that still continue? So again, even if he can say, I was taught this and no one ever told me he was wrong, fine, but couldn't he see that George Floyd wasn't moving at all? And to Sue Ann's point, the crowd was alerting him that he wasn't moving at all.
And he made that concession during the direct or the cross-examination, which kind of began today and still have to get into it more so tomorrow. He did make the concession that at some point when a suspect is no longer resisting, you don't need the knee anymore. So ultimately, he agrees with that point. I think, though, that one of the things that stands out for me in his testimony was this whole piece about I can't breathe. He conceded to having heard that, but didn't take it seriously, and suggested that officers don't take that seriously anymore because of Eric Garner in 2014. His assumption was that it's used as an excuse by suspects as opposed to something that officers should take seriously. If I am the prosecution in this case, I am hammering that point home during my closing argument, and I'm further hammering it home during the rest of the cross-examination. That really goes to what his intent was. He knew what was going on. He knew or heard that an individual was in distress, even if he didn't see it constantly because he was looking at this crowd. But he heard those magic words and he chose not to act because he didn't take him seriously, because what I've heard and what I've seen since 2014, certain police officers have been socialized to make light of that claim as opposed to using it as a red flag to act. And he admitted that on the stand, and that to me is shocking and I think troubling for the defense in that case.
Well, let's talk about, of course, cross-examination resumes tomorrow, so we'll see if he messes up even more. But I didn't think that he did himself a service today. However, he didn't have a choice. And I think much like Tou, the other two don't have a choice but to take the stand as well. Sue Ann, what do you think we're going to hear from the other two who are also going to be taking the stand? Are we going to hear something similar? I know that they all play different roles, but the idea of, listen, we didn't know that this was wrong, especially when it comes to the other two who have less experience than Tou.
Yeah, I think they're going to get on the stand and they're going to really toe that line of we were rookies and we were just following along with what the people who are more experienced were doing. We're just rookie cops. This is just the beginning of our career and we didn't know what to do because we were brand new. The problem is, from day one, as a police officer, you have certain authority, you have certain power, you can use certain force. And so from day one, you have to be ready to go. You can say, they can testify that they were rookie cops and that should excuse what goes on, but that doesn't excuse their responsibilities to the public and their responsibilities to make sure that people that are in their custody and the public in general are safe. It absolutely is not going to be an excuse, but I'm sure we will hear several times the word rookie and discuss how long or how short of a period that of their experience on the force, for sure.
Well, let me go back and expound quickly on why I think Lane probably has the better chance of being acquitted on all charges. Tony, this was the officer who only had, what I think, 4 or 5 days into his actual job out patrolling. And he was the only one that tried to make suggestions, I believe the only one who made suggestions to Chauvin on more than one occasion to roll George Floyd over to his side. And he was the only one who went into the ambulance to perform aid on George Floyd. So this is why I believe he probably has the better chance of the 3 of being acquitted. Your thoughts quickly.
And I think that he was only charged with one of the counts he was not charged with because of that, his clear efforts to give assistance at some point. I do believe, though, that it will fall short because he will ultimately suggest that the entire fault belongs to Chauvin. Well, guess what? He just got out of academy. It should be freshest in his mind what he's supposed to do in those circumstances because he was just trained for the 6 months preceding that period of time that he was involved there with Officer Chauvin and there on scene. So although I believe and I agree with you that his situation is distinct and different, and I think it's incumbent on each of the defendant's attorneys to try to distinguish them from the group. And he certainly has something to go on there. But at the end of the day, I think he will have difficulty because, again, relying simply on the fact that he was inexperienced, well, the training that he had just received was required for him to even be there in the first place. So there's no excuse really. And, can't rely on this guy was doing a bad thing, but I'm new, so I stood down. That's, in fact, what makes him guilty.
I do think that all 3 will be putting the blame on Derek Chauvin, who obviously was convicted of murder. But I also think that Lane's testimony will also hurt the other 2 co-defendants because he is the rookie, but yet he was the one that stood up to Derek Chauvin in his own way and suggested that they flip George Floyd over on his side, which flies in the face of what Thao claimed in terms of what he was trained to do. So definitely more on this. Cross-examination again resumes tomorrow, so we'll be watching. Attorneys Sue Ann Robinson, Tony Thedford, thank you so much for being here tonight. I appreciate you both.